Hi, I'm John Counsel. I'm the senior reporter with Texas Lawyer newspaper, and welcome to the May 16th, 2008 edition of Reversed and Remanded. And today my guest is Betsy Branch. She's an associate at the Dallas office of McCurley, Orsinger, McCurley, Nelson, and Downing, a long name for a firm, very prominent Dallas family law firm. And Betsy is one of the 300 or so lawyers that have volunteered for the FLDS polygamist ranch case. And you're ad litem, correct?
Yes, I am.
Okay. And the reason I have Betsy on is she's getting ready to go to San Angelo on Monday for what is known as the 60-day hearing, and that's a statutory hearing that has to be held when a child is removed from the home. And Betsy, this is going to be another weird, complicated hearing, I would imagine, because we still have all of these hundreds of children who have been taken from their homes. And now I understand that the way they're going to handle this is they're going to have, I think, is it like 5 judges are going to hear these cases based on, I believe, the maternity of the child. How in the world is this going to work?
Well, actually, it's probably the best way to handle it with these particular children, in that because of the pluralistic marriage situation, the only way you can actually identify the family is by the biological mother.
Right.
And so if you collectively sever all these children from this huge case and then group them back by their mothers, that is the only way you're actually going to establish the parent-child relationship, because it's not in the sense of a traditional marriage with a husband and wife. The husband may be a party to 4, 5, 6, 10 different SAPSR cases, but the mother will only be in one SAPSR case.
Yeah, and we early on there was a thought there would have to be DNA tests, and I think they did swab a lot of the children and their mothers to make sure they could match them up. But are they finding out that there's enough birth certificate information that you're not going to have to do that?
Well, actually, CPS is not looking at any of the birth certificate information as being valid.
Okay.
A lot of these birth certificates, because you have to understand this ranch was developed in 2004, but for the children who were born here in Texas, many of them with midwives, many of them not having birth certificates.
Okay.
You have children born prior to 2004, born in another state. But a lot of the areas in which those children were born are in areas that already have a heavy polygamous base. Many of those same polygamists work in government offices. So CPS is not putting a lot of veracity or credibility toward the official government documents that they're producing.
And what's going to happen in a 60-day hearing? Is it just sort of a status hearing, or will a judge actually make calls on whether or not a child could go back to be with a mother?
Well, of course, a lot of the ad litems are hoping that the court will consider many motions that have been filed by the individual ad litems for these children. But in all likelihood, and what the word is coming down, is that if you are requesting relief that is outside the scope of a 60-day hearing, then they're not going to entertain that relief. One of the other things that they're doing is that they are putting forward the parent reunification plans to the court, and many of those parent reunification plans are, well, in fact, all of them that I've seen are blanket. They developed this plan in Austin without regard to any of the individual particularities for any one child or any one child's family.
Right.
And so this is just broadly, in order for these parents to be reunified with their children, they're basically being given a choice between their children and some of the fundamentals of their religious beliefs.
So expect some objections to be lodged to this at this hearing, I would imagine.
I expect a lot of objections to be lodged, and I think that there will soon possibly be some 1983 arguments being made to federal court.
Oh yeah, that's just around the corner. Okay, let's move on to another case. We have a front page story this week. I thought it was fascinating. Maybe you will too. My colleague Brenda wrote about a lawyer who was in a lot of trouble here in Texas. His bar card was in trouble. He was in criminal trouble as well, and it was from taking money from his clients. He disappeared, reappears in Canada as a very successful businessman. I think he had kind of given up his bar card before he left. And the interesting thing here is that the Harris County DA's office wants to extradite him back to Texas and try him on criminal charges. And the machinations have already started, I guess, to have him brought back across the border. But the interesting thing is, he says, look, I owe my clients money. I am more than willing to pay them. Just don't extradite me. Now, Betsy, can you see any way that that's going to work, especially when the DA's office says, no, we're not going to let this guy pay his way out. He's got to come back and face justice. And another thing to note is Betsy was a prosecutor in San Antonio for years. Mm-hmm. So anyway, what do you think?
Well, I don't think he's going to be successful in thinking that between the United States and Canadian government, he's not going to be extradited.
Yeah.
But actually, if you look at the fact that this man's indictment was in 1995 and we're up to 2008, so we have had 13 years that the government has not gone after him. I understand that he hired someone to go to Harris County and to negotiate a plea bargain and deal, but it appears that they're not interested in doing so. I like to think creatively, and I think possibly if they were to offer interest on the $70,000 that's been accruing over all these years, that it might make it a lot more palatable to some of his crime victims who may be willing to sign affidavits of non-prosecution.
Yeah, alleged crime victims, because he hasn't been done anything and hasn't been convicted of anything. But yeah, that's an interesting way to go about it. Let's see, and then my final thing I want to talk to you about is the so-called embryo case. This has been in the news for a year or two, and it's a dispute between a former husband and wife. They had frozen embryos, and I believe it signs this contract that said if they ever split up, they would destroy the embryos. But when they got separated, wife wanted to use them and claim them as community property. Trial court judge rules for her. On appeal, the appellate court says no, we're going to abide by the language of the contract, and then it made its way up to the U.S. Supreme Court, and just this week the Supreme Court said no, not going to hear it. Now, I'm not real surprised that they didn't want to hear it, but did this case end up the way that it probably should have, you think?
I think the case ended up exactly as it should have. You have to look at the long-term ramifications. Had she been able to be awarded these embryos as community property, I believe in reading what I understood from other newspaper articles prior to this one, that it had been her intent to become pregnant. Then you're going to be looking at child support. You know, obviously a husband who is no longer willing to be the father of her children, for her to give birth to these children after the marriage. Would he be a presumed father? Are they going to look back at the date of the conception? Because you only have a certain limited period of time for a pregnancy to occur before a marriage is dissolved to be a presumed father.
Right.
And of course he is going to, he is going to be the DNA dad. So does he want to pay child support for the rest of his life? I think the court came down the right way on this.
So it's smart for them to have a contract on this, so that it would guide the courts in their ultimate decision. But what if there wasn't a contract? Would it be a different story? Would she have a community property right to the embryos?
Well, do you have a property right to your children?
Interesting.
And I don't.
And it gets into the question as to when does a child start? I mean, do they have to take a breath first? Yeah, it's a fascinating question.
So that could have many, many layers to look at.
Oh yes, I love those kind of questions. All right, it's time to put Betsy at what I like to call the witness stand. I'm going to ask her some questions and see what she has to say. Okay, Betsy, here's question number 1. Is divorce ever fun?
Sometimes for the attorneys, yes.
Never for the clients. All right, Betsy. My sole possessions are a 1987 Honda and a credit card with a $20,000 balance. Should I get a prenup?
No, I wouldn't get a prenup unless I knew that, maybe stuck between the seats was an unclaimed lottery ticket that was worth something.
Okay. All right, Betsy. Has anyone ever put you on retainer for a divorce while they're still single?
No.
Okay. Betsy, have you ever told a client, look, pal, you could have bought a new dining room table for what you just spent in legal fees trying to get the old one from your wife?
No, it wasn't over a dining room table.
So this has happened.
This has happened.
All right. Betsy, thanks for coming over.
Thank you, John. I had a lot of fun.
Good.